Welcome to today's webinar, Digital Accessibility Lawsuits in 2024. My name is Elijah Kerr Brown, and I work in marketing here at UsableNet. And our featured presenters are Jason Taylor, Chief Innovation Strategist at UsableNet, and Joseph Piesco, Partner Chair Labor Management Relations Group at DLA Piper. And I'll hand it off to Jason now.
Thanks. Thanks everybody for spending some time with us today. I'm really excited to have Joe with me to give some great legal color. Joe and his firm do a lot of work in this space. A quick introduction to UsableNet. We're a company that's provided support to a wide range of companies over the last 20 years to ensure accessibility. As part of that, one of the things that we do is we track all of the most prominent ADA lawsuits filed federally and state, and I'll talk about that in detail. So if you see a lot of numbers today, that's basically from the work that we do there to help our clients understand the risks and how to reduce those risks while they're making their sites accessible. I'd like Joe to give a quick introduction to him and his firm, if that's possible, Joe.
Yeah, thanks, Jason, and thanks for having me. I'm a senior partner at DLA Piper in the Labor and Employment Group. I've been handling disability ADA work for approximately 28 years now. DLA, as many of you might know, is one of the largest firms, global firms in the world, with significant presences in 90 different offices around the countries. So I'm really happy to be here and excited to be a presenter with you, Jason.
Yeah, let's just quickly look at the agenda. I mean, the format today, I would say it's almost a sort of a conversation between myself and Joe. What I bring to the table is the sort of numbers that we've been tracking in the first 6 months of 2024. And what Joe brings is legal clarity around, what's behind those numbers. So hopefully you'll enjoy this format. We're going to go over what the numbers look like this year so far. We're going to look at a typical claim. I think it's useful for people who have maybe not received a lawsuit, or people who have received the lawsuit, to understand like what's in a typical lawsuit claim. Look at where most of those lawsuits are filed and why. Which industries are most likely to receive a lawsuit and why. We will also have a call out for lawsuits that essentially are in play with websites that use accessibility widgets, and the importance of that from a legal perspective of Joe. Joe's going to take us into a little bit of like what's happening in the legislation in 2024 that might really set the scene for the rest of 2024 and 2025. Joe's going to help you understand what you might want to do if you get a lawsuit, or if you get a demand letter, or if you get any legal action in this space. And what I hope to do is just give you a quick sort of get started, how to reduce that risk and increase accessibility sort of takeaway at the end. So with no further ado, if we can maybe start with the first, sort of data. And before we bring that data up, let me just explain the methodology with regard to the numbers that you see in our report. So again, UsableNet produce a report every 6 months. What we do is work that I don't think many others do. Essentially, what we do is we download every federally filed ADA lawsuit. Now, that could be a lawsuit at federal level against a physical property, or it could be against a digital property. We filter the physical ones out. We then only track the federally filed lawsuits, where the digital property, for example, a website or a mobile app, is the subject of the claim. We add to that any claims that have been made at state court against websites using state legislation. So not federally filed, but state filed. You'll see that the most active states are in New York and California, and Joe will give you a bit of a brief reasons about why that. But essentially, we track both federally and state filed lawsuits because we can track them through data that's provided by public record. We do work in terms of tracking what those companies are, types of industries, and then we produce reports around trends that we think are useful for our clients. So with regard to the data so far this year, if we pull up the big numbers, there's probably some things to talk about here. So the numbers over the last 5 years, which is in the chart on the right-hand side, started in 2018 with around 2,000, and last year was about 4,500. This year, we expect to end up around about 4,000. So we're about 2,000 in after 6 months. We've seen a slight dip in numbers this year, and I get Joe to talk about the dip in numbers. I think the other thing that we've noticed is more and more lawsuits being filed at a state level, so not just federally filed, but actually we'll talk about how some of the plaintiff firms have moved their filings from federal to state, and maybe Joe can give us a reason why that is. And I think it's also very important to note here that we only track things which can be verified by public record. So lawsuits are subject to public filing, so we can track them. Demand letters are a private letter that sometimes supersedes a lawsuit, and are used also to make claims of discrimination. And I get Joe to talk briefly about that. But maybe, Joe, you could cover why you see maybe there's a little bit of a drop down in numbers total. Second, why you're seeing some move from federal court to state court, and then third, what you're sort of feeling is with regard to the number of demand letters.
Sure. Thanks, Jason. So I think that the slight decline is really attributable to more and more demand letters coming out with draft complaints. And I think that the plaintiffs' firms are key to, avoid, if they can get the kind of settlement that they're looking for by avoiding having to deal with filing fees, and also to avoid the current stigma against these, the 10 or so major players for filing, cookie cutter complaints religiously on a weekly basis. So I think that some of the federal judges, including in New York, and now I think we're going to see a sea change maybe in the Western District of PA, which was a very friendly bar for plaintiffs filing these lawsuits. One particular firm files religiously there. So I think that the combination of being able to garner a settlement along with not inundating the federal judges with these cookie cutter complaints is what's driving that slight dip. And I think that also coincides with why we see like sort of the split here between federal and state, which would have been higher last year for federal. And I think the reason is it's just a part of forum shopping. They've been using the federal court system so much that the judges are now showing a bit more hostility, as we'll see in some of the future slides, particularly with respect to whether Article 3 standing is met per the Constitution. And I think that what's happening here is because that hostility is increasing, if the plaintiffs can get by a demand letter or they can't get by a demand letter, they're going to run to the state court where they might have a more friendly attitude towards the standing requirements, including California and New York, because their state laws have injuries and potential monetary damages associated with a discrimination claim such as this. So they probably more easily establish standing under a state statute.
Great. So yeah, just so I make sure we read that, the split between federal and state is 56% federal and 44% state. That was more like 80-20 probably a year ago. So that's what we mean by a significant change towards state. I think the summary of what Joe says there is overall, the overall amount of clients that Joe's supporting is not going down. It's probably going up. But he's supporting them either because they've been had a claim made in a federal court, a state court, or they received a demand letter. And the demand letters are hard to estimate, but I know, Joe, you said to me before you felt there's probably more actual demand letters than actual lawsuits, maybe even twice as many. I don't know if that's a good paraphrase of what you've told me in the past.
I think that's accurate, Jason. I mean, plaintiffs' firms, the way they work is they have a stable of serial clients. And so they're just sitting in their, proverbial basements in front of a computer with their screen reader, surfing e-commerce websites for the most part. And then, they hand it up to the plaintiff's, the lawyer, who then sends the demand letter.
So let's look at what a typical claim is. I think that the takeaway also here about, is it federal, is it state, or is it demand letter? Practically, probably for a company, there's not a lot of difference. There's definitely not a lot of difference in terms of what is claimed. There's definitely a difference in how you will need to respond to it from a legal perspective, and that's essentially why you might want to hire someone like Joe and his firm that specialize in this space, because they know the types of claims that are being made by the types of plaintiffs. They know the venues such as federal or state, and they know what to do with a demand letter. But I think from a practical perspective in here, whether you get one at federal, state, or demand letter, they typically have a similar structure in terms of what they claim. So firstly, they are typically made by a visually impaired plaintiff. Some are made by plaintiffs that have audible disabilities for video, for captioning, but I would say the vast majority are visually impaired plaintiffs who are user-assisted technologies like screen readers to use the website. They claim that they are unable to complete tasks that are similar to other people able to do class. So very simply, I could not complete purchasing a product on an e-commerce site, and other users can. That's essentially, I would say, the base of the claim. They would typically maybe include some type of list, and this is really sort of the plaintiff firm trying to sort of justify, why they're making this claim. They'll look at the website with a sort of a free scanner and look at WCAG violations that they can list. They might reference that there's a feature on the website, such as a widget that creates a barrier for screen reader users, because actually widgets can create barriers for screen reader users where they could help others, but essentially screen reader users are the people who are making the lawsuit. They might make reference to a lack of an accessibility statement. That's essentially saying clearly you're discriminating because you haven't got a statement of accessibility. That again, there's no law saying you need to do it. It's essentially creating some sort of story to present into the plaintiffs. But I think the most important number here, and I get Joe to talk about it, is the 4,000 cases that we talk about this year and the 4,500 last year, and also all the demand letters are typically made by the top 10 plaintiff firms. 83% of those, that activity is made by plaintiff firms. So it is not 4,000 individuals struggling, going out and getting 4,000 lawyers and suing 4,000 companies individually. It's more of a process around identifying volume of websites, which can be added to these types of claims. Joe, could you just give me a little bit on that sort of makeup of the plaintiff bar?
Yeah, I mean, that's absolutely right. I mean, we see the same players over and over and over again, and I'm not going to list names here. And we track the settlements, we track the claims internally. So we, at least at DLA, we know when we're speaking to XYZ firm what their likely starting number would be for a settlement, what they likely would want to include in the settlement. And these guys have a cottage industry, right? And it really is based on volume, as Jason said. And the old adage, if it isn't broke, don't fix it. That's exactly what's going on. And unfortunately, a lot of clients would rather settle, and the plaintiffs' firms know exactly where the prime number is, because they know that whether it's motion practice or even answering the complaint or what have you, you're going to spend 10, 15, 20 times the amount of what a typical settlement is, depending on, again, the firm. I mean, typically we see some of these settlements go from $5,000 to $10,000 to $12,500. Again, depending on the firm and the issues at hand. But one thing that I could say is, as consumer advocate groups, like the Chamber of Commerce, which we've been approached a couple of times, want to start fighting back on these claims. And as the courts become more hostile, the hope is that, we'll be able to drive the number of these suits down. So I think that's what we're going to start seeing in the next 2 to 3 years to 5 years.
Yeah, I think it's important. One is just to clarify, people may have come to this from a not knowing anything about an ADA website claim or even an ADA claim. I think it's worth understanding that these claims are basically made, and what they're asking for in settlement is And what they can only ask for in settlement in most cases is the legal fees that are involved to bring the case, and for the company to fix their website, right? So to remediate. There are no large damages that can be awarded by a court. A court can essentially, at the federal level in particular, can only issue basically a hey, you've got to remediate, you've got to remove the barriers if they're there, and you've got to pay the legal fees of the plaintiff. There are some state ones where you could argue you could add $5,000 worth of damages, but it's not a movie where someone gets 100 million damages. So this is primarily about a decision at the company level of saying, well, do I pay a defense lawyer to defend me a lot of money, or do I pay a little bit less to a plaintiff firm to settle and agree to remediate the website? Joe, would that be a good paraphrase of what mainly your conversations are, out of this volume?
Yeah, absolutely. I mean, you mentioned the state laws like California and New York, right? I mean, California's Fair Housing Act has like a $4,000 damages per injury or something along that nature. So that's why we see a lot of cases filed under the California Fair Housing Act. Same with the New York State Human Rights Law and the New York City Act. So, I think that that's right. It is a cottage industry, and what drives it is the legal fees. And just to add too, we're starting to see mobile app cases as well become more prevalent by these testers. So if you have a mobile app, you're going to want to discuss with either a company like UsableNet or someone how to make sure that your mobile app is also going to be accessible.
So let's look at some of the trends that we've seen, and I think that sort of helps create the idea of a profile of the most likely companies that might be targeted with lawsuits. The first is in the area of regional. So as we talked about, we track all the federal circuits, the 11 federal circuits, and we track all the active states where we're seeing lawsuits being filed at a state level under state legislation. The result essentially is that the vast majority are actually in New York. The next big area is California, and then the third is Florida, and everything else is a little bit smaller. A quick one from Joe. Why New York and why California? Why are those two the most likely places that you're going to find a federal or a state lawsuit?
Yeah, thanks, Jason. I mean, for the most part, if you're going to be filing in state court, you're going to do it in New York and California because you have, like I said earlier, less of a barrier to entry to the court through a standing argument in state court as you might have in federal court. Federal court in California, not a great place to be for these ADA cases. They have generally not sided with the defense bar on the standing issues. New York, as we'll see, is coming around a bit. It was a bit more favorable, but now judges are becoming much more hostile to all these complaints, clogging up its docket. And Florida, without really having a state counterpart there, the lawsuits are always invariably filed in federal court. But I think, like we said before, Jason, as we see the federal courts become more hostile to these plaintiffs, these serial plaintiffs, I think we're going to see continue to see an uptick in state court filings.
Right, and I think the key takeaway if you're a company is it doesn't matter if you're headquartered in New York or California. If you provide services, or you provide your website and you sell into these states, or provide your services in these states, you're subject to these to be subject or available to be sued at federal in those circuits or at state level. Joe, correct?
That is correct.
Okay.
And we're
So the
also,
next,
just to add there,
Joe.
Jason, to add there, we also seen a significant uptick, Jason, in lawsuits based on informational only. Like they visit your website to get some information and could not navigate the website because of alleged barriers. So it may not even be the case that they visited to purchase any goods or services. And we're seeing those more and more New York and in California, which is where it all started.
Yeah, no, I just want to put a little note in, right? That there's a couple of reasons why these lawsuits exist. I mean, one is that most websites have some significant barriers for people with disabilities using that website. The legal argument is whether websites should be subject to the ADA, and that's the type of thing that Joe gets involved with. But I would say that if you talk to anyone who uses a screen reader for everyday life, they expect and they feel the ADA should support them in ensuring that they get access to the same things everybody else does. So there is a strong element of advocacy around this subject matter, which is the ADA is there to enforce equal access to public accommodation, so places of public space, right? And that's essentially the argument that the plaintiff lawyers use. They essentially say this website is available to everybody, but my client couldn't use it, and that means that it's that this company has discriminated against my client, and I'm going to use the ADA to enforce remediation. That sounds really legitimate and powerful and empowering. I think that what a lot of companies don't like is just at the sort of volume level and maybe at the sort of discrimination level, it doesn't feel like genuine customers are contacting them with issues and they remediate it. The first contact that they get is from a lawyer saying that the plaintiff couldn't access their website. And I think that is the most sort of jarring sort of part of this from a business perspective, because the business didn't feel like they had the opportunity to take action to solve the problem. Joe, would you add anything there?
Yeah, I'd agree. And I'd also note that, it doesn't matter, like, and we'll talk a bit about this, it doesn't matter the size of the company, really. We see a lot of startups who are growing so fast, focused on, selling and building up their market presence and whatnot, that they don't focus on the accessibility issue at all. But we also see large companies who have retained us for help with, various of these alleged, barriers. So there's no like one size fits all in terms of who could be subject to a demand letter or an outright lawsuit.
Yeah, and it actually helps us move into the next section, right? So where we're seeing most lawsuits, and there's a chart here that basically emphasizes that almost 80% are e-commerce based companies being sued. The next likely is food service, so food ordering, takeaway companies, pizza shops, those types of things. Then it's education, then it's entertainment, then it's very, very small numbers in travel and hospitality. I want to emphasize here that any company could get sued. But if you understand the practicality of what Joe talked about, you've got a volume type attitude. So you need to find something of volume. There's a lot more e-commerce sites than there are of anything else. From a very limited legal perspective, and I'm not going to try to be a legal person, right? You've got to tell a judge that there was a reason that your client wanted to or needed to use the website. So, e-commerce sell things. It's quite easy to justify that someone wanted to buy something, right? So if I wanted to buy a pair of shoes, I can say to a judge, that's why I brought case against 10 shoe companies, because I tried all 10 sites. I was trying to buy shoes. None of them allowed me to purchase shoes. That allows me to generate standing, and the judge can't really deny that you want to buy shoes, right? So it's more likely that if you're sort of well known, if you're easier to find, you're more likely to be sued, because it's easier to justify that the plaintiff was trying to do something on your site. So that's why I think e-commerce is number one. The other reason for e-commerce is e-commerce sites are complicated. It's easy to find barriers for screen reader users to not be able to do something, select a color, add to a basket, change credit card. It's very easy to find those barriers, and that can be documented, and that goes into that nice template of, hey, I can't do something that someone else can. Joe, would you add anything else in terms of why you feel e-commerce is a target?
Yeah, I think that you're spot on, Jason. And I would also add that, in the e-commerce space, things are constantly shifting and it's a moving target, like constantly updating your website. The websites are becoming more and more complicated. The websites would, have audio, have video clips that, are captioned. And I think that it does make for an easy target. And plus, like again, there you have a stable of these tester plaintiffs, these serial plaintiffs that do nothing but sit down and peruse the web, and go shopping. And that's what they do. And e-commerce sites are focused on marketing and selling, and like continually updating their websites. And what happens is, even if they use accessibility widget, which we'll talk about, they're not getting themselves to WCAG 2.1 compliance.
Great. So let's just look at the last trend, which sort of Joe touched upon, right? So a number of these companies, and it's something that we do in the methodology. So when a company gets sued, that day we go to the website and we see whether they're using an accessibility widget. That essentially allows us to say, well, unfortunately, this company probably already invested in some type of accessibility effort. They've put a accessibility widget on, probably hoping that that is going to satisfy people's needs. And essentially, that hasn't satisfied the screen readers' need. And essentially, there's still issues for the screen reader user, and they bring suit. So they're not being sued because they use a widget. Essentially, the widget is not helping them avoid lawsuits. And that number's rising all the time. That may be to do with some plaintiff firms targeting websites with widgets, but I also think it's the fact that lots and lots of companies, are mistakenly feeling confident about adding very, very cheap widgets, thinking that they're going to solve complicated problems, which wouldn't make any sense. If you asked any web design, web development company, the more complicated the website, the more likely the fixes for accessibility are going to be complicated. The simpler the website, maybe a widget can help if it's just information. But essentially, if you've got a complicated website, it's almost naive to think that a cheap solution is going to fix a complicated website for accessibility. Joe, what else have you seen in the area of widgets? I think you talked about, for example, some plaintiffs in settlements requiring that you do something more than just a widget. For example, I don't know what the phrasing of that was.
Yeah, no, I mean, look, we've seen a significant uptick of both in demand letters and suits, with respect to the use of widgets. Let me just say this to everyone who's listening. The fact that if you're using a widget, you should ask for a full compliance test and proof from the entity that you've hired to provide that service, that you're 2.1 AA compliant. And in addition, if you're not using a widget service and you're considering it, you should be asking the company that you're looking to hire to put their money where their proverbial mouth is, and agree to indemnify you in the event that you get sued. Because if they're so confident that their widget will raise you to WCAG 2.1 AA compliance, then they should stand by their product. The other thing, Jason, as you just mentioned complicated websites. These widgets don't fill all the holes, and with constantly there's a lot of space in between that the widgets just can't seek out and cure, if you will. So, that dovetails with the more complicated your website, the more space is, I'll use that word, space is in between solutions, and it's not reaching it. And the other thing too is you should be aware that a lot of these lawsuits go on to where they say they tried to check out and they couldn't pay or whatever. If you're using a third-party payer portal, you're going to want to make sure that company also has its portal accessible, because you don't want to get tagged with that.
Great points, Joe. So let's move into that sort of area of like what have you seen? You talked about, hopefully, you're going to help drive sort of some of you feel the volume down, making it harder for plaintiffs to bring suits. What trends in the legal space are you seeing that's going to help do that, do you feel?
Yeah, so as per the slide, right? So New York courts were, for the last 5 to 10 years, becoming more of a favorable forum. But I feel, and it looks like the way we're seeing these cases come down, few and far between, but they're coming down, where courts are throwing out plaintiffs' claims based on the fact that they haven't conclusively or factually pled at what we call an injury in fact under Article 3. You have to have an injury when you come to a court in order to lay a claim. And first case on the screen is Martin versus Second Story Promotions. If there's any attorneys on the call, you might want to check this case out. It's a really good read, and this federal judge really laid into the plaintiff and called out plaintiff's counsel as well, because they're just filing what the court noted as carbon copy complaints. And they filed 9 on the same day that they were in the court. The judge looked it up, which I thought was pretty clever. So more hostility now in the Second Circuit in the New York courts. The next case, the iHealth case, another one where the judge just wasn't convinced with the cookie cutter allegations, conclusory allegations. And the plaintiff there was supposedly buying COVID-19 tests, but couldn't explain any of it. So I think that that's important to note, that the Second Circuit is becoming less of a favorable jurisdiction. The Western District of PA has been a significantly more favorable jurisdiction for plaintiffs' claims. And there's one firm out in the Western District of PA that routinely files them there and has a clever letter that notes that good luck trying to move to dismiss my claim on standing grounds, and citing all of these court cases. But recently, in February of this year, we had a judge that actually went back to the nexus test. And for those who aren't familiar with that, that's an important standing argument for the defense bar, because if your website doesn't have a quote unquote nexus to a physical location, now that looks like the Western District of PA is more apt to toss the case on standing grounds. So, I guess sort of stay tuned on where this is all going to head. And one note for everybody, just so you know, because so many cases settle, because companies don't want to spend significant monies over and beyond what, a settlement would be. That's one of the reasons we just don't see a lot of law coming out, because by the time they get filed in court, they're usually settled within 30 to 60 days after that. I think that trend is going to be upset. I think that we're going to see more defense motions to dismiss based on what this trend looks like. So so stay tuned. Now, we had a shot with the Atkinson Hotels case that went before the Supreme Court to finally resolve the Article 3 standing issue by, this was a tester plaintiff, like most of them are, arguing that they were she was a tester. Before the case could be ruled upon, the plaintiff, who lost her lawyer for reasons we don't need to go into, voluntarily dismissed the case. She probably was bombarded by other members of the Big Ten, I'll call them, law firms, plaintiffs' firms, because this could have made seriously bad law for them and put a dagger in the entire system. So unfortunately, we don't have a case before the Supreme Court, although Justice Thomas, as you can see here, did note that the whole notion of a someday intention to come back and visit the website isn't going to be enough. So we're going to have to stay tuned on that. Now, importantly, down below, you're going to see some other trends, right? So in California, right, we have they published, I'm sorry, in the Department of Justice, rather, we've been waiting for well over a decade for the DOJ to issue some form of proposed regulations on this space, and they still haven't done it under Title III. But now with Title II, which is for state and local governments, right, they've adopted the WCAG 2.1 level, AA as the accessibility standard. And that might be where we're going to foreshadow a bit, where maybe the Department of Justice is finally going to issue or propose some regulations in this space. California had AB 1757. That was held after it was introduced. And then Senate Bill 1486 was introduced, containing a presumption of compliance for websites meeting AA under WCAG 2.1. So there again, we're seeing now states proposing legislation that, you know, if you're CAG 2.1 AA, you will not be in violation of the law, at least the California Fair Housing Act. Interestingly, Virginia has a proposed law, HB 1355, which would require public institutions to actually pay for someone to come in and do an accessibility conformance report. This is something we have not seen before. I don't think that this is going to get signed into law, but it's now been postponed to 2025 anyway. So this is another one of those stay tuned. I just don't see how the government's going to be able to force every company that does, you know, that sells its goods and wares in its state through a website to pay for somebody to do an accessibility report, Jason. You know what I'm saying?
Yeah, it doesn't sound like a scalable solution. It doesn't really sound very in line with, for example, the DOJ's Title II. I mean, my input on this is, especially for anybody who's joining this call and thinking, hey, how do I get more awareness in my company, or how do I get more support for accessibility in my company? You know, we've got a lawsuit, but, you know, maybe we're just sort of like going to settle that. I think the gates are closing in. For example, if you add to Title II, right? So, you know, pretty much every government agency now, typically, if they want to buy something or use a service from somebody else, they are going to require that service is WCAG 2.1 AA compliant, right? So, you know, if your company has any plans on doing any business with state, local government, and any federal government in the United States, they're gonna start pushing that this is a requirement of doing business in their master service agreements, right? Same thing goes for Europe. Europe has a whole bunch of laws going in at every single country level. That includes anyone who provides services or sells to governments in Europe. So again, if you are a company and you're thinking about having any type of contract with any type of government agency in the US or in Europe, you're going to find that these requirements are going to be written into the into the contracts. So you may as well use this opportunity to get ahead of it and reduce your risk of, you know, private lawsuits in America, while supporting your sort of offering at the state or federal level across the globe. That's my sort of general input on the legal side. I don't think there's going to be a get out of jail free card by any state, I imagine, right? But I think it's really important that it's almost like, what should we do, and that's going to come at the end. But almost like, if Joe talks about settlement today, right? So we probably estimate 95% of cases settled within 3 to 6 months. Joe's explained why, because it's cheaper to settle and say, hey, I'm going to fix the website, don't worry. That's cheaper than moving down the path of discovery and going into a court to try to justify you've done enough. So, and I think it's worth Joe explaining, what would you settle? What would you say in a settlement? What typically are the plaintiffs looking for in settlements? And I think Joe's got an interesting take on these are becoming more complicated. Joe, if you could take us through that.
Sure. Yeah, I think what the plaintiffs are trying to do now, as you can see from these are most of the asks that we generally are now seeing. Beforehand, over 5 years ago, what have you, it was really a typical settlement was pay some legal fees and agree to remediate the website and get it up to 2.1, or 2.0 at the time, whatever, AA. And we'll give you a couple years to do that, usually 2 years, which is always plenty of time. And that has now changed. And my view is that plaintiffs are now trying to more legitimatize their serial lawsuits by their tester clients by asking for some pretty interesting stuff. It's kind of clever. By the way, most of the stuff I would not agree to in a settlement. So just because it's their wish list doesn't mean that, you know, DLA, my group, or, you know, any other member of the defense bar would agree to all these things. But we are now seeing things like, we want you to post an accessibility statement. We want you to control your third-party content and make sure that's accessible, including like your payer portals, like I mentioned earlier. They want training done for all the people in customer service, all the design and development teams. So if you're using an internal development, web development team, they want you now to train those folks on WCAG technical tools so that they can properly code the website. We're seeing them ask for monthly accessibility audits or quarterly accessibility testing. They're asking for, you know, the names of the developers and having an understanding of, you know, whether or not, if you're controlling developers, they want assurances that the developer is going to fix any bugs that still linger. And they, you know, it's not on the slide, but they also want to come back in and test your site. That the plaintiff has the right to come in and test the site to make sure that you are complying with the settlement agreement.
Yeah, and I think it's interesting here, but one of the things you said, right? Everything's a negotiation in this world, in this process, right? It's a negotiation on price, on settlement price, and that's going to be based on how well you prepare your defense counsel, like Joe. Well, you know, how well you prepare them with the work you've done, you know, giving him some ammunition to, you know, argue that actually, you know, you've done lots of work, and if it went in front of a judge, we'd make a big argument, you know. So, you know, trying to basically emphasize that, you know, that they've got less of a case, and Joe's going to try to do a best job there. This is also a very important part, and it's somewhere where we work with Joe and his firm, where, you know, they're going to basically try to make sure that the list in the settlement is as streamlined as possible, and UsableNet can easily support that requirement, right? So we actually, you know, work with Joe and his firm on settlements and say, okay, here's a list of services or a list of solutions that we can match up to those settlement items, and that gives the client confidence that they can actually do what they're signing in the settlement letter. You know, it can be done, and they know roughly what their effort level is going to be, rather than signing the settlement letter and then going out to a vendor and saying, hey, can you do these things for us, and not knowing what that effort level is going to be.
Agree wholeheartedly.
Yeah, so, you know, this is where, engaging someone like Joe, who can really help you streamline this, but also understanding that someone then has to do this, and UsableNet can help with, well, that's really tough to do, so you don't want to agree to that. But this is, you know, something that you should do, and actually is going to help your team anyway, so you should probably agree to that. And again, this is something that companies should do. You know, to the settlement point of view, you're only settling with one user. Any user could sue you if you don't go and do these things. Another user can sue you the next day in many cases. So you want to get ahead of this. You want to be doing the right things. And Joe and his team can help you do this, you know, in the most affordable way, but also help you think about, well, we don't want another one of these, so let's do the right things, the most important things that Joe and his team feel are the right things to do.
Yeah. And on that note, Jason, just one, because we're going to this next slide, what you do if you receive a lawsuit, right? On that note, you know, before we even get into this thing, for those who are listening, if you have a terms of service on your website, you want to make sure immediately that the terms of service are screen reader capable. And you want to make sure that your terms of service have a strong arbitration provision and a class action waiver in it. And if anybody wants to seek out some more information on that, I'm happy to provide it, Jason. But it is a significant deterrent to the plaintiff's bar when they see that you come back and you move to dismiss the complaint, or threaten to move to dismiss the complaint on arbitration grounds. So I'm telling everybody here, I think it's an excellent idea, and there's not one company that shouldn't have a terms of service with those that's screen reader capable and that has an arbitration and class action waiver provision.
Yeah, I'd add another to preventative, right? you should have this clause of requirement of an ADA, compliant with everything that any company's buying. So if you're paying a vendor to build your website, if you're paying a vendor to build your mobile app, if you're signing up to a third party, as Joe said, payment system, right? Legally, you need to be saying, well, you're responsible for the accessibility. You've got to start pushing that early, right now. Like any money you spend, it comes only if you guys are taking care of accessibility, because as Joe indicated, you are responsible for the accessibility of everything on your website, whether it's yours or not. And most of you aren't building these websites yourself. You're paying someone to do it, and you're paying someone to maintain it. So I think, getting out there right now and saying, actually, this isn't our responsibility, this is our vendor's responsibility, and making sure that they're aware of it, they've got the capabilities, they've got an ability to report to you. These are preventative ways. To Joe's point, legally, you can put pressure to give yourself a lot more, probably quality of product, but also more options to get money back if you do get sued. Joe, could you just cover what you think are the main things you would do if someone receives a complaint? And that's a demand letter or a lawsuit. I think they're very similar, but.
Yeah, I agree. Whether it's a demand letter or an actual lawsuit, you're not going to want to ignore it. Eventually, if it's a demand letter, it might take them some time because they send so many out. But probably within 60, 90 days of getting a demand letter, they're apt to file the complaint. So you don't want to ignore it. And I think you want to speak immediately with counsel to talk about how to handle it and what strategy you want to employ. You want to have somebody like UsableNet come in here and take a look at your website and see if there's any legitimacy to the allegations that it's not compliant with WCAG 2.1 or 2.2 at this point. Check and see whether or not it's a serial plaintiff. Chances are it is. And then you'll want to discuss with counsel whether you have arguments to move the dismiss, for example, on standing grounds, as we've talked about earlier. And if you're going to settle the case, you're going to want to have a really good company by your side, like UsableNet, which I know stands by its product in all respects, to come in and help you, work on either training your people internally to make the fixes, or to have UsableNet do it themselves. They're quite capable in this regard. They're probably the #1 company. That's why I use them. So you're going to want to consider all these aspects, and of course, you're going to want to consider, the monetary consequences, right? How much is it going to cost to settle versus how much is it going to cost to, either move to dismiss the complaint or otherwise engage with the plaintiff's firm.
Great. And then sort of I'll just give you, based on our a quick sort of summary of, if you haven't received a lawsuit and you're thinking, hey, maybe we're in that profile, based on what we've talked about here. Again, it's a volume business, so the more well-known your brand is, the more likely it's going to come up on a list somewhere and it's going to get tested. If you've got more than one website and more than one brand, more likely you're going to get more than one lawsuit, because they'll sue multiple websites, but on an individual basis. Selling to consumers in New York and California, or providing service to New York and California, that's your second profile. Physical location, that's the nexus. So what Joe means is there's a physical presence that using a website is connected to. So, find store location, shop and pick up in store, order pizza, go get it. This is basically a nexus. It means I use something to access a service which is actually in a physical location. Complexity of website, again, easier to find problems because they move all the time. As Joe said, they change all the time. No accessibility statement essentially is used as sort of another sort of bullet point. And actually, we believe in putting one up, very broad, believe in accessibility, ongoing project. Please contact us if there's a problem. Don't need to talk about standards. Don't need to talk about where you are. More about the fact that you believe that that you've got a front foot activity with regard to supporting people with disabilities. If you use third-party widgets, what you're typically doing is giving up control and hoping a third party is going to do it for you, and you've paid them very little money, and a lawsuit can cost you anywhere between $10,000 and $30,000. That doesn't sound like a logical or a good business decision. So essentially, that's what we typically see in terms of profile. And again, for me, just finally, what could you do to mitigate? So first, it's what websites and apps are public, right? So which of those websites? Quickly test them. We have a free service. You can test as many websites as you want on our website. So at UsableNet.com, are there issues that are easy to find? If they're easy to find, they're easy to put into a lawsuit, right? So get those issues over to the company that you pay or the team that you hire to manage your website. Get them to remove those easy to find issues. That's going to improve the accessibility of the website and reduce your risk. We always advocate for finding someone in the community, in your client, in your customer group, someone who uses a screen reader. Get them to tell you whether there's a problem or not. If they say there's no problems, I can do everything I want to do, well, keep that. That's great evidence for someone like Joe to use against a claim. If they tell you there's problems, that's probably going to help you to motivate and target the most important problems for them if they're screen reader users, because they're the ones that sue. So again, I think that's a good way of filtering out your efforts. Easy to find stuff with a free testing tool like the one from UsableNet.com. Get someone with a screen reader to tell you yes or no. If there are barriers, focus on those barriers. Get this stuff written into your contracts with your vendors, so the vendors are on notice and they're helping you get a more accessible experience. These are all going to reduce your risk. I'm not saying they take it away, but they will definitely reduce your risk. So maybe, Eli, you can come back and pull out a couple of great questions for Joe. And Joe, I really appreciate your time today. I love the color that you've added.
Thank you, Jason. It's my pleasure.
This question is, what trends are you seeing in captive or internal digital applications? For example, a mobile application that enrolled students at higher education institutions used to purchase food from universities and dining halls. Have you seen any trends in those?
Well, the way I can answer that is that what we are seeing an uptick, as I said earlier, in attacks on mobile apps. I've not personally been involved in a litigation on the higher education side, which would have some different legal standards applicable to public institutions and educational institutions. But what I can safely say, and I don't think it's speculation on my part, is that we are going to see a lot more lawsuits against companies that use mobile apps such as those.
Yeah, my input on there is that the new Title II probably covers this area, right? So any state or local university that wants to purchase something is going to require that you sign that things are accessible. For me, this wouldn't be about lawsuits. This will be about who you're trying to sell to. If you're trying to sell to education and what you provide is not accessible, you will be found out and you will lose contracts. It's going to be added to every single educational contract there is out there. In the educational space, complaints are done differently. They're done through the OCR. They're done through the Civil Rights Division of the State of Education. So the enforcement will really be about, well, you're going to be probably signing contracts and MSAs that say that you're providing a fully accessible 2.1 AA conforming application to your clients. That's where you're going to get sued, not from a private citizen, but from the universities that end up having complaints from students or staff because of that.
Well said, Jason.
We're looking ahead to the European Accessibility Act since it affects US sites that can accommodate European customers. Do you have any information about those requirements or differences with the ADA? Jason, you want to go first?
Yeah, we actually we're producing a series of blogs. I will tell you that they're very similar to Title II in terms of what you've got to do. But I think the thing to understand is that what the European Act did was tell every single country in the EU that they need to produce their own laws. So you've actually got to focus on what is the law in the countries that we do business in. They're all very similar with some slight changes. Essentially, most of it is around if you if you sell or provide service to or use to the government of that country, you are liable under that act. Each act has, in each. So, for example, Ireland, there's a maximum penalty of $75,000 fine. Germany has a different structure. So the European Act essentially said, hey, every country, you need a law by 2025. So every country has a separate law. I would default your process of thinking, okay, we need to do what Title II ADA requires, because essentially that will allow us to sell to federal government and pretty much keep us safe in Europe. I don't think you would come unstuck in Europe if you basically make sure that you're targeting that you can sell to state and local and federal government in the United States. If you're 2.1 AA compliant, you will be absolutely fine in Europe across all of the different countries. But I think that's a key thing is there's not a European law. There's a European law that tells every country to create its own law. Each law is slightly different, but they're all pretty much very similar to Title II AA in terms of requirement.
Yeah, I agree with that. I think that if you're 2.1 AA, you're going to be safe in most every country.
And that'll conclude today's webinar.